and you'll get bored. I do have to catch a plane, so I probably have to stop no later than 7:45, but I'm planning to only go for an hour. And if it goes longer, that's fine. But please ask questions as we go along. So the idea is to have new California laws and California cases. So just briefly, as most of you probably know, the minimum wage for fast food workers was increased, and it goes up over the number of years, and there are exceptions. It's pretty complicated. But the important part about this new fast food worker law is it sets up something called a fast food council that will meet to establish annual wage increases. This is a really interesting legal concept of something called sectoral bargaining. Sectoral bargaining is where employers and unions get together and bargain wages for a sector of the industry. So, for example, it could be auto mechanics or whatever. This is fast food workers. And the National Labor Relations Act, which governs bargaining in the private sector, doesn't set up a mechanism to do sectoral bargaining. But it turns out California has a history of sectoral bargaining, as do other states, because WC orders that some of you are familiar with from the early part of the 20th century, more than 100 years ago, were also sectoral bargaining. There were IWC orders set up for various sectors. So this is really an interesting development. And the wage goes up to $20 and then goes up after that, 3.5%, and creates various standards. So it's really an interesting concept, and it certainly raises all boats, since if workers start going to fast food work because they're getting paid higher, it forces other employers to match that. All right, so we all are concerned about rights of workers to exercise their rights under the law and not be retaliated or discriminated against. And in order to figure out whether someone's been retaliated against is often difficult, because employer will discipline somebody or fire somebody and say, oh, they made a mistake or something. And it's sometimes hard to establish it. So SB 4097, which is mentioned here, says that if the employer does something adverse to an employee, like discharge them, with 90 days of exercising certain protected activity described in the labor code, then it's assumed that the employer's conduct was illegal. Now, that's not what we call a conclusive presumption, meaning the employer isn't tagged as being guilty right away. Then the employer has to come up with a good reason why it engaged in the activity. Otherwise, it's kind of reversed. You got to show that the union or that the employer was motivated out of retaliation. Now, the fact that the employer took action, it's presumed it was retaliation. And so this is a kind of a movement forward. The Labor Federation has been really good about getting the legislature to impose these kinds of restrictions. Just a little thing, all these things are helpful. AB 520 now says that if a public agency hires in the property services and healthcare, hires a contractor who doesn't pay the wages, then the public entity can be responsible. They're jointly responsible. Both are responsible. And so that makes it much easier to protect workers who get hired to work for public entities and then don't get paid by their employers. So you're all interested in paid sick leave, so this will take a little bit more time. AB 616 expanded paid sick leave from 3 to 5 days. All right. It also increases the number of paid sick leaves that you can roll over and increases the cap. Okay, but as I think most of you probably know on this call, the paid sick leave law in California allows construction industry employers who are unionized to totally exclude themselves from paid sick leave. And so in the building trades, most of the building trade unions have reached deals with their employers whereby they give up state paid sick leave and they've gotten something in return for it. And the state building trades wanted that because providing paid sick leave for construction workers is a lot different than providing for retail grocery workers or mechanics or somebody. And so the building trades thought it didn't make as much sense to require paid sick leave for construction workers. Notice I said unionized. So non-union have to provide the paid sick leave. So it's actually a kind of a lever against the non-union and benefits the union contractor who doesn't have to provide paid sick leave. Right now, this new AB 616, which expands paid sick leave, has a trick to it. It goes from 3 to 5 days. So under state law, a union outside the building trades can negotiate different provisions for paid sick leave. So we can agree to 3 days or 4 days or 5 days or 8 days or 10 days, and we're exempt in large part from the qualifications of state paid sick leave. So for example, state paid sick leave applies to not only taking time off for your own healthcare needs, but also for a spouse, children, grandparents, and this expands it to other relatives. Well, the trick is that expansion does not apply if you have this collective bargaining exemption, unless certain other things occur. So for example, you have to provide some form of paid sick leave to everybody who is employed by an employer after 90 days. So if you have a group of employees who don't get any paid sick leave until 6 months, then the union's collective bargaining agreement doesn't comply with state law. Now I'm going to stop here and just say the following. 5 days in the non-union. They're all protected. You can't be retaliated against. They got to be paid. In the union sector, we can negotiate something different. But if you have any questions about whether what is in your collective bargaining agreement is sufficient to exempt the employer from state paid sick leave, you got to talk to the union and we'll take a look at it. But all your friends are working non-union, you should remind them that in most cases you get more paid sick leave, better paid sick leave, but at the minimum, they're entitled to now 5 days effective January 1st of 2024.
January 1st, okay.
Fair enough? 5 days outside the unionized, sometimes more than 5, sometimes 5, rarely less than 5, but technically you could do that. Okay, interesting case that was decided in last year called Wood versus Kaiser. So just a matter of explanation, when the governor signed paid sick leave, as Governor Brown in 2015, the statute expressly provides that only the labor commissioner can enforce paid sick leave. And the reason for that was the employers didn't raise as much of a big stink as they would have, knowing that only the labor commissioner could enforce it because the labor commissioners never had the resources to enforce it. But it was a step forward. Right. This case, however, now holds that we can enforce paid sick leave through the Private Attorney General's Act. So if you've got friends out there who are non-union who don't get paid sick leave, let's talk about it. These are good lawsuits, and more importantly, I can make some money out of them. All right, that's paid sick leave. So let's move on to wage theft. Wage theft is a problem, and the problem is how you fight it. And this is just a change in the law, which entitles prosecutors now, that is, the Attorney General, district attorneys, to take on wage theft cases. And prior to this law, there were only certain district attorneys who could take it on. Now they all can take it on. So if you're in a jurisdiction with a decent district attorney, you can go to them and say, hey, we've got this rat out there, they're stealing from workers, take them on, and they have the right to enforce most of the pay laws. So it's just a little bit of progress, broadening the right to enforce it.
Wait a second, David. Jeremy had his hand up. We want to take
I apologize. I don't really watch when people have hands up. So Jeremy, take yourself off mute and yell, David, I got a question.
All right, I didn't want to just interrupt you, but I wanted to go back to the.
I want you to interrupt me because I'll just
okay.
Keep talking.
Understood. I want to go back to the sick leave real quick. Does it do anything with people who accrue PTO that can be used for stays or anything like that?
Yes.
Does it? Okay.
So what it says is that, and that's a really fabulous question, actually. So some people paid sick leave, they have paid time off that you can use like sick pay. And if they have paid time off that you can use like sick pay, that paid time off has to either be negotiated or comply with state law and provide all the bells and whistles of paid sick leave. So, for example, although state law allows a union, it sounds a little complicated, but let me say it. What state law says is the union and the employer can agree to only 3 days of paid sick leave. But if they agree to 3 days of paid sick leave and 2 days of paid off, that acts like paid sick leave, those 2 days extra have to comply with paid sick leave in the sense that you can't retaliate against people for taking it. You have to allow workers to use it for the wide range of relatives who are sick. So if you've got a collective bargaining agreement that, for example, provides 3 days of paid sick leave and 5 days of paid time off that you can use like sick leave, let's talk because it has to comply with AB 616. Doesn't that sound complicated, Jeremy?
A little bit, but I understood. Thank you.
Well, it also means that if you got a collective bargaining agreement like that, send it to me or Karen or somebody and we'll take a look at it. This is true of any of you. And if you got friends who've got sick pay provisions in employee handbooks, happy to take a look at it. All right, just a little side note, AB 800 is a bill that now authorizes Labor History Month and Workplace Readiness Week. So it allows high schools, actually requires them to provide some workplace readiness laws and training, and the UC Labor Center is in the process of preparing those trainings to use in high school, and hopefully part of that we'll be learning about apprenticeship, unions, and things like that. So high school students will learn a little bit about when you go to work, you get all these good laws. So they'll do these kinds of trainings I'm doing for you tonight about the laws that they can expect to use when they join the workforce. Just nifty. I actually kind of like it because I taught for a couple of years before I went to law school. I taught some of these got me in trouble. Anyway, so California's been the forefront of protecting providers and workers who want to assert reproductive rights and abortions and gender affirming healthcare. And I won't go into the details, but it just means if you're in California, there are lots of protections if you're looking for gender affirming healthcare, abortions, reproductive rights. And that also means that if you've got friends who live in states that are less friendly, Texas or Mississippi, those folks can come out here and get the kind of health care they deserve because it's protected. And one of the reasons California did this was to protect in case there was really bad federal legislation. And interestingly, the Trump camp has been saying, well, we leave it up to the states. Well, that's bullshit because their base, the right wingers, want a federal law prohibiting these kinds of rights. So we've affirmed it in California. And that's the purpose of this slide. So one thing, just a technical thing that may affect your members is effective January 1st, California employers with 5 or more employees must provide employees who've worked after 30 days, 5 days of reproductive loss leave. Right, so this means that if there's a miscarriage or failed surrogacy or stillbirth or events like that, the worker can get 5 days off. Now it's unpaid. The employer must keep it confidential. The employee can't take it 2 years after the loss. It's got to be within 3 months. So there's some limits. But basically, a worker has the right to go to the employer and say, I had reproductive loss. I don't want to discuss it further. I just need some time off to deal with it. So as union, either stewards or business agents or activists, you hear about some worker who's got some issue, and you're free to go up to that worker, like Shelley. Hey, Shelley, I hear you've got this family issue. I hear it may be something that you can get some time off. If we can help you get time off and you need it, please talk to me. I'm trying not to pry. And if they say, yeah, I really do need some time off, and explain to you, you may be able to find ways of getting time off for them. And they thank you because the employer isn't going to do it. So they're 5 days for reproductive leave. And that's Sal Vasquez. I'll ignore him for a moment. And California, a year ago, enacted a law that says workers get 5 days unpaid leave for funeral leave. And now, again, to be clear, that 5 days is on top, is not on top of what you already have. So if you have 3 days in your collective bargaining agreement, this law means now they get an additional 2 days unpaid, so a total of 5. So again, it's just another leave law, of which there are many in California.
Can an employer use that timing, for, the loss of a child or whatever, as part of the tracking that they do for people's attendance records for which they get disciplined if they don't come up,
No.
job?
No, they can't be retaliated against or punished in any way for taking this time off. It's protected. And that's a sort of a background question that's kind of helpful. That go back to 1993 when Congress enacted the Family and Medical Leave Act. Imagine that, 1993, 30 years later. Remember, it was all unpaid. And the purpose of it was to protect workers so that if they took time off, their job would be protected. That's all it really does. It says if you take time off for a family or medical leave purpose, up to the 12 weeks provided in the statute, you can be assured you'll come back to your job. So it's either intermittent leave or chunks of leave, whatever. You don't worry about attendance points being given to you and you're losing your job. Leave laws serve that same purpose of saying you can take time off and you don't get attendance points or discipline for it. Some of them provide for pay, very few of them. The only one that really provides for paid leave is the 5 days of paid sick leave. The rest are just, you get to take the time off and you can't be disciplined.
And it's different from Family Medical Leave Act.
Pardon?
It's different from someone using the Family Medical Leave Act.
Well, no, FMLA is unpaid, it is protected. There is one pay element that under FMLA, the employer has to pay your health care. But for reproductive leave, these other forms of leave, they're very short term, so it normally doesn't affect your health care, but the employer doesn't have to pay you.
Okay.
Now, some of them provide that if you have vacation pay on the books or sick pay, the employer can require you to take that. So you can't take time off and then keep your paid time off or paid sick leave.
Thank you.
More questions?
Hey.
Come on.
Hey, David, it's Greg with Local 1414. Just wanted to know, all right, so I'm taking screenshots of your presentation here. And
I'll send them to Shelley.
okay, that's perfect. Thank you, sir.
Okay, now when I send them there are more slides than what I'm showing you. Some I've hidden just because I didn't have time to do all, but I'll try and do it tonight. If not, tomorrow I'll send her the slides.
Thank you.
All right, farm workers can now unionize by card check. Just interestingly, the PRO Act, which we supported in Congress, which doesn't seem to go anywhere, provided for some card check recognition procedures. The state enacted a similar card check procedure for farm workers under the Ag Act. It's been used very few times to organize, but it's there. All right, this is something that actually I had to go through today that's unique to California, but really important, and all of your employers have to comply with it. Effective July 1st, 2024, which was just 4 weeks ago, California employers have to put in place a workplace violence protection plan. This is designed to deal with a situation where there's a threat of some kind of threat of violence. I mean, obviously it deals with an active shooter situation, but it's really designed to deal with what happens if an ex-employee starts making threats, or the spouse of an employee makes threats, or a customer makes threats, and what is the employer going to do about it? And so every employer in California has to have this workplace violence prevention plan, and they have to train the workers. So I'm an employee, so I had to go to an hour-long training today done by those in my office about how the plan works in our office. And, a couple of people have developed a really fabulous presentation, but every employer has to have this plan in place and has to distribute it, make it available, explain it. But it also, as this slide shows, unions encouraged to bargain. So before employers implement this plan, they should bargain with the union. You can get a template, an example of the plan from the California State OSHA website. And so most employers use that template and kind of fill it in, but you have to tailor it to your own business. And that's really, to me, a really important law. It's just groundbreaking in California. We do this and it works here, and then other states adopt it. Just another side note, effective January 1st, 2025, unions will be permitted to file TROs on behalf of the employees it represents. So if you've got an employee who's being threatened by a supervisor or somebody else, the union can go to court to seek a TRO. So I'm speculating that we can file some TROs against abusive supervisors. And if your employer doesn't have a workplace violence prevention program, you got to let the union know about it. Okay, SB 4028 is the other side of the coin. It allows employers to seek restraining orders, protect employees facing harassment. And that would be from an ex-employee or a customer or whoever. So if you've got that situation, you hear about it, there are remedies. So cannabis, we keep getting legislation cannabis. Okay, it is now illegal effective January 1st for an employer to discriminate against a person in hiring, termination, or any other condition of employment if based on the use of cannabis off the job and away from the workplace. Now that sounds pretty broad. So if Shelley comes into work someday and says, hey, I really had a great party last night, we smoked weed, you can't be fired just because you used cannabis off the work site. But you can if it impairs your work or affects your work in any way. So employers can discipline or penalize employees based on drug tests that I'm sorry. They can't now discipline simply because a drug test detects THC, which is the psychoactive cannabis. They have to show some impact, right? So they have to prove that there's enough drug in the system through this test that there was some impact on your ability to work. And so most of our drug testing procedures in collective bargaining agreements will have to be amended. Now, like every other law, there's some exceptions. This does not apply to employees in the building trades because the building trades want to be exempted. They want drug testing. It also does not preempt federal laws or other state laws. So, for example, truck drivers are subject to stricter rules under federal law. This doesn't preempt federal law. So most folks who are now protected from using cannabis during non-work hours, just don't bring it to work to sell it, don't bring it to work to use it, and don't come to work under the influence of it. And also don't come to work under the influence of alcohol and have enough THC in your system that it could show you're under the influence. So again, this is just groundbreaking law. It still faces the problem that cannabis is unlawful under federal law, but the federal government isn't enforcing it. Who knows what will happen? And so effective January 1st, now you can't ask job applicants about their prior use of cannabis. So it protects folks in the application and hiring process. And again, does not apply in the building trades, does not apply where federal law says otherwise. So that's great news. All right, so those are a bunch of the laws that were enacted by the legislature effective this year. So I wanted to address a few cases that have come down that address some of the finer points of this. And Huerta versus CSI Electrical Contractors, which was decided in March, is one of those cases. And this is a construction site kind of problem. And just so you understand what happened, because this may affect some of your members in some work locations. These are workers who were working on a remote construction site in Monterey County and they had to drive down a road to get to the construction site. About halfway down the road was a guard shack where they had to stop. They had to show identification, and sometimes the guards would look in their trunk and stop them. But often there was a long wait of 2 minutes, 5 minutes, 10 minutes before they could go through the guard shack. And there were limitations on how fast you could drive on the road, and you couldn't go off the road and so on. And then you drive to the work site, get out of your car, park it, and go to work. All right. And so the question in this case was, does the employer have to pay me for the time I'm at the guard shack? And the Supreme Court said yes, because for the time you're at the guard shack, you're under the control of the employer. So assuming you're there for 5 minutes, you got to be paid for the 5 minutes. And do I have to be paid for the personal car between the security gate where the guard is and the parking lot? And the answer is, I think the court said, no, you don't, because you're not under the control, even though you are driving on a road with limitations. So what this case holds now is that if you come to work and you're under the control of an employer going through a security gate, and this is not sort of a new proposition, we've seen this with big warehouses, some kind of security, you have to be paid for that time. So for example, UPS workers, when they go into a UPS building, they go through an initial screening gate that they get identified, and then they go through another screening gate with a guard, which takes some time, and then they check out. So between the time they initially screen, go through the guard and check out, and then continue walking to the work site for that first initial period they're paid for it. And that seems to comply with Huerta. So this, Huerta clarifies when you have to be paid. And it also works in reverse, that is, you got to be paid on the way out to the security gate. All right, an issue that we're waiting for the Supreme Court to decide is rounding. So employers in California have traditionally rounded up or down. So if you work past the end of the shift for 2 minutes, you wouldn't get paid for it, as long as if you showed up 2 minutes late, you didn't get dinged for it. So there was a kind of a rounding practice that's developed. And a couple of courts have said you can't round for reasons related to California law. And the California Supreme Court is going to decide that question in this Woodward's case, and we'll see what happens. All right. Some of you know about the ABC test and AB5 and all that. The Ninth Circuit, which is the court that we deal with, decided a case called Olson versus California in June. It rejected a challenge to AB5. The challenge in that case was the state really had no reason to create all these exemptions. It undermines the purpose of the law. And the Ninth Circuit had bought that argument a year and a half ago, decided to rehear it, and rejected it. But the big news really is that the California Supreme Court a week and a half ago decided the Prop 22 case and upheld it. It was a 7-0 decision. All justices agreed that Prop 22 was valid. As you may remember, this was a challenge by gig workers to Prop 22, and the court only considered one issue. Since 1913, California's had a provision in the Constitution that says that California has to have, or does have, a complete system of workers' compensation. And so the argument was Prop 22 withdrew from gig drivers the protection of the California Constitution for workers' comp, as it provides a system that's like workers' comp, but nowhere near adequate. And the Supreme Court heard argument and ruled 7-0 that even though the California Constitution says that, it doesn't mean that, as opposed to an initiative process, and people have the right to kind of overrule what they said in the Constitution. So Prop 22 is upheld. However, the court did say something really interesting that we've been talking about, we're talking about before and after, which is, interestingly, the court reads Prop 22 to say that the only thing the state can't do is apply the ABC test in AB5 to gig drivers for workers' comp purposes, meaning to give them workers' comp. But what it doesn't say, Prop 22 does not say, is the state couldn't adopt a separate workers' comp system for gig drivers. So we're talking about whether we can do that. All right, this was a case that Shelley asked me to talk about, and I didn't find it that remarkable, but Shelley wanted me to talk about, so it's a good chance to talk about something important. So as I think all of you know, that California is one of the states that has a layoff, payoff, or payoff when you're terminated provision. So what California law says is if you're discharged, and that's the word of the statute, you have to be paid all your accrued wages at the time of discharge. So if I walk up to Shelley at 4 o'clock and say, Shelley, I've had it, you're too much trouble, you're fired, I have to give her all her pay, including all accrued vacation pay or sick pay or whatever is accrued. And if I don't, there's a 30-day waiting period, meaning that she gets 30 days of pay until I give her everything, no more than 30 days. And that includes both discharge as well as layoff. And traditionally, we've all assumed that if I'm laid off with no expectation of recall, I'd be paid off when I'm laid off. If I'm laid off with expectation of being recalled within a week, I don't have to be paid off because it's just a temporary layoff. Well, the Hyatt, back during the COVID period, laid off a large group of people and said, didn't say you're discharged, didn't say you're laid off, said you're furloughed pending resumption of our guest census. We're going to bring you back as soon as our guests reappear. So the question was, did they have to be paid off when they were furloughed? And the Ninth Circuit said that if you furlough people without a specific return date within the normal payroll period, it's like a discharge and you get 30 days pay. So there's 1,000 or more workers, you can get another 30 days of pay. So this is an important point to remind your friends who are non-union. If they get laid off, they get paid off, everything on the books. If they don't, and the employer waits 2 weeks to pay them, they get 2 weeks of pay if they go to the labor commissioner. So that's what the Hyatt Corporation case stands for. Does that answer your question, Shelley?
Yeah, thank you.
Okay. And there's another discussion here about hotel rooms that I don't need to deal with. All right. This is just another technical issue that California Supreme Court issued, but the question is whether under Labor Code 226, which provides penalties for knowingly and intentionally failure to accurately report wages, the question is, in this case, the employer said, well, I thought I did it right. The Supreme Court said that's not good enough. You have to do it right. Right. So when we get payroll statements that are inaccurate, Naran helps us. Right. This may be something none of you encountered, but we keep encountering, so I'll mention it, that increasingly non-union employers are developing arbitration agreements. So your friends who are working non-union are stuck with these horrible arbitration provisions that prevent them from going to court over any claims. Now, it may be an exaggeration to say they're horrible because some actually work, and I've used some of them effectively. But federal law, there's a federal law called the Federal Arbitration Act. And the Supreme Court has really done in California law with respect to regulating and making arbitration fair by saying California law is preempted, foreclosed by federal law. And so the question is, what California did was said, here's a problem. What's happening is workers are demanding arbitration of wage claims and going to a service that provides an arbitrator, and the employer is not paying the fee. So the AAA and the the AAA, JAMS, and these other outfits that provide arbitrators charge you for it. And under the law, the employer has to pay that fee. So there were these cases where employers say, oh, we're just not going to pay the fee. Too bad. No arbitration, just sit there forever. And so the state has tried to fix it by saying that the employer has breached the agreement and it's void if they don't pay the arbitrator's fee within 30 days. And that's an issue that the courts are going to have to resolve, whether that state law, which regulates arbitration, is preempted. But right now it's on the books. Right. So some of you may know about the Private Attorney General's Act. It's just this great law that gives workers the ability to enforce the state law. But we have had this running battle for years with the Chamber of Commerce and other employers wanting to modify it. And They threatened a ballot initiative, and the state Fed negotiated a deal with the chamber in which we gave up some things in return for which POG is still on the books. And this just illustrates what the changes are. Don't worry about it. The thing I should say is that if you do have an employer who gets sued on a PAGA theory and they're a union employer, give us a call. There's some things we can do to help those employers, because often these are kind of bogus lawsuits. All right, so here we are, 7:09. I'm going to take maybe 10, 15 minutes to go to the other area that Shelley asked me to address, which are remedies under the National Labor Relations Act. And I'm not just jumping from one thing to another. These remedies under the National Labor Relations Act are remedies we can ask for in court suits as well as arbitration. So if somebody's discharged, we can say, hey, the labor board now imposes this remedy, you should. So just some background before I jump into this, that under the National Labor Relations Act, the labor board has sort of broad authority to determine what's an appropriate remedy. So if somebody's fired illegally, the remedy is they get reinstated and back pay. And the labor board today, which is controlled by the Democrats, has been trying to figure out ways to expand those remedies because to some degree they're pretty useless. So there's this case called Thrive Inc., in which employees were laid off without providing the union with notice. And the board said this layoff was illegal. So the question is, what's the remedy? Well, the normal remedy is put them back to work, give them back pay, and lost benefits. Well, the labor board said, we're going to go a little further. We're going to say that if they can show direct, and here's the phrase, or foreseeable pecuniary harms, then they'll get those. So what are some examples? The employee has a credit card and has to put more on the credit card and pays a higher interest rate. Well, that's a pecuniary and economic harm. The employee gets fired and has higher childcare expenses because they have to hire a childcare person so they can go look for work. Or they have to travel further looking for work. Or they borrow money on their 401k and then they have to pay that back. And so one can think of many economic or pecuniary harms that may arise when someone's terminated. And so Thrive says, we're going to give those remedies. Now, this is a case from December of 2022. Thrive got appealed to the Fifth Circuit, which is the horrible court in New Orleans, which is packed with Trumpite judges. And recently, that court reversed Thrive on grounds that don't really affect the merits of it, on sort of procedural ground. So Thrive is still the rule, and the general counsel is thinking these remedies were appropriate. And I have a case that I argued in the Ninth Circuit several months ago that has a Thrive remedy in it. And I just got an order from that court today, wondering whether this Thrive remedy now entitles that employer to a jury trial. And that's because Supreme Court decided this case called Sarkozy, SEC versus Sarkozy, holding that the SEC can't impose a penalty on an employer without giving that employer a jury trial right. So the Ninth Circuit wonders if that applies to Thrive remedies. We don't think so, but that's what's happening with the Supreme Court these days. So what are some other remedies? So Noah's Ark Processors from 2023 says in a footnote, look, we're going to consider a lot of other remedies. So this just lists some, and I added some. So providing employees with an explanation of their labor law rights. So a remedy would be that a labor board agent would come to the shop or the plant and have a discussion for an hour telling the workers about what their rights are. And it's paid, and the employer can't be there. Now that'd be a fabulous remedy because employers would not want federal government agents there. Now, I'm arguing in a case that's actually starting tomorrow in Las Vegas that the employer should allow union reps on the work site to have these meetings. But I get that far, now it's another question. Another is the notice explanation of rights to employees. So the labor board 4 or 5 years ago, actually in the Obama administration, tried to require that all employers post a notice that gives employee rights to workers. And a court shot it down, saying the board wasn't authorized to do it, but said the board could do it as a matter of remedy. So the board now, in some cases, says to employer violated the law, you got to post a notice, this notice of employee rights to employees. Making supervisor manager present at the meetings where notices are read. That's just to shame them. Mailing the notices to employees' homes. Having employees actually sign the notice, not just the lawyer sign it. Publishing the rights notices in local media. Posting, the traditional posting period has been 60 days. Make it 120 days or 2 years. Or something called broad orders, and then in this case I've got Tomorrow Station Casinos. This employer station casino has been horrible in Las Vegas, and we're seeking all sorts of extraordinary remedies. And my favorite is I think that the owners should be sent to a dungeon. And if you wonder how horrible a dungeon is, check it out after I'm done. All right. So remedies: notice reading by email, by mail, and here's another one: apologies. The NLRB is now requiring that employers sign apologies in which they say, we apologize for violating the law. So I've actually gotten an apology letter as part of the settlement. What happened was I wrote a letter to the employer about their unlawful conduct, and a lawyer wrote back a nasty letter threatening to take me to the state bar for writing the letter. And I filed a charge with the labor board saying I was being coerced because I sent this letter, and the labor board agreed, and that lawyer had to write me an apology letter, which I proudly posted. So that's another remedy that the board is seeking is training. So they're saying that supervisors who commit violations have to have trainings about labor rights. And I keep offering to do those because they're very hard to do and very complicated. When I do trainings for supervisors, it's usually like at $2,000 an hour. Visitorial clauses, so that the board can come to the work site and talk to the workers about whether the employer is complying with the law. And then there's EXCEL, that should be EXCEL. That's a remedy that says if the employer bargains in bad faith, that they'll have to make the employees whole by somehow paying them the difference between what they made and what they would have made had the employer bargained in good faith. All right, so those are just some nifty remedies that the board is seeking. So I tried to go through some state laws so you can use them to organize remedies before the labor board. You see what they're doing. Obviously, if the election goes badly, wrongly, or horribly in November, all this will come to a crashing halt. But for the moment, the Biden administration has done more through the labor board than any prior administration ever to increase these labor rights. And we just move on in California, increasing labor rights through state legislation. All right, any questions?
Speed training.
I hear a tiny voice in the background. I think that's Shelley.
Well, I want to leave time for other people to ask questions because I got my own, but is a little hard to understand because you went so fast. What what is ECELO? I don't know what that is.
I'm sorry, when I put it should be EXCELO. It's an old board case about 40 years ago that said that when an employer refuses to bargain in good faith, the remedy is the employer is ordered to bargain in good faith in the future. We want to overrule EXCELO and say that if the employer doesn't bargain in good faith, and we can show what the employees would have gotten had they bargained, then the employer has to pay the difference. It's called a make-whole remedy. That remedy actually exists under the Agricultural Labor Relations Act. So under the Ag Act, if an employer doesn't bargain in good faith, let's assume the Ag Board can show that had that employer bargained in good faith, everybody would have gotten a $1 an hour raise for the 5 years the employer screwed around. Then under the make-whole remedy, everybody gets a $1 an hour plus interest to remedy the fact that the employer didn't bargain. That's EXCELO. Now that's on the agenda to change, and again, assuming we win the election, which we will, then that will change in due course. Just to add some of you may have heard about this CEMEX decision. It's a case Karen's been handling for the Teamsters. It's now in the Ninth Circuit. It's just had a huge amount of publicity around the country, and it's another remedy case that deals with what happens if the employer commits unfair labor practices that interfere with an election. I'm not gonna go into detail of what it is, but it has to do with when can the labor board order an employer to bargain, and made it much easier for the labor board to order an employer to bargain under CEMEX. That case is on appeal, likely to be argued in November or December. And there's a lot more I could tell you, but that's a case where, again, the labor board is trying to say we have broad remedial powers to remedy unfair labor practices, and Excella would be this make whole remedy.
So if you stop the screen share, then we can get everybody up there, and then we can see if there's anybody else who has a question that don't know how to raise their hands with the electronics.
Hi, Deborah. I didn't realize you were there. Hi, Leon. I like your nose.
Thanks, David.
Leon. So you're gonna send me the slideshows, and I can forward these to the other folks that are interested. But
Yeah, I'll do that. I'll correct Excella, Excella to Excella and send it to you.
okay.
And send to those of us who are here.
Deb.
Leon, I like that nose a lot. Where'd you get that?
That's a Babe for that movie a long time ago. And I
Is
just,
that Babe?
yeah, the movie's called Babe. That's the pig.
Yeah, it shows you what I watch. Greg's got a nice sky behind him. I like that. That's pretty.
It's cute. Any questions?
Question? No, there's a lot going on. It's just we get these court decisions. Congress is kind of stymied about doing anything on the federal level, but administrative agencies have done a lot, and now the Supreme Court's going to hamper them from doing a lot with this new case called Loper Bright and Corner Post. But we're just making a lot of progress. And what we're doing in California, other states are doing. Washington, Oregon are doing things, kind of following our lead. We're the laboratory that makes things work, and then everybody follows us.
David, I do have a quick question regarding the Workplace Violence Prevention Act. I understand it's effective July 1st. So what are the penalties for the employer if they don't comply or if they don't train their employees on the safety plans?
I don't think there are any penalties. It's just the state can force you to do it. I'm not 100% sure. I don't think there are penalties to it, like monetary penalties. But I will check.
Okay, yeah, no,
Do you
because
have some employers that have not put it into effect?
right now Safeway is playing a stalling game. They're trying to put together a training plan that takes only less than 10 minutes to complete, and it's basically online. And there's a lot of non-English speakers, in our stores, and they're, of course they have like Spanish versions, but it's a less than 10-minute slideshow that they go through by sitting them in a room, and basically it just goes through everything really quickly. And then at the end, you probably don't really learn anything about safety and how to react in certain situations. So basically the plan is more than useless.
Well, that is, doesn't seem that complies. I mean, the law says, for example, you got to make available the plan to every employee. The employee has to have a copy of it. You have to do training. You got to do training once a year. There are a lot of requirements, and Safeway isn't complying. We need to talk.
Is there a requirement on the length of the training? Because I think the employers are trying to cramp this in a really fast training and call it done.
That's right, because they have to pay for the training time. So I don't think 10 minutes is adequate. So if that's what Safeway does, let's talk. We'll go to Ocean, find a good test case where the training is that bad. So the union is entitled to a copy of the training. So you should both insist on bargaining over the training and ask for a copy of it. The training I did today in my office was almost an hour.
David, what type of things should we be bargaining over for that training?
Well, go look at the OSHA's website, because there's a template and it shows you what's included.
Okay, thank you.
So there has to be an employer plan about who gets notified, what do they get notified about, what are employees supposed to do if there's a threat, who are they supposed to report it to, what are the physical safety aspects of the place where you work. Those are some of the things that are included in the plan that they have to disclose to workers.
Jeremy and Leon, because this has come up a couple of times. We tried to do this once before, but I'm gonna ask Laura Stock at LOHP or somebody from WorkSafe to actually do a specific training on the workplace violence stuff. Because the other thing that, like what Leon asked about the penalties, what I get frustrated at is an employer will be penalized, and they'll go to the appeals board, and then the penalty is greatly reduced, or they say, oh, we rectified and remediated whatever the problem is, and they aren't held accountable. So the question is, how do we do that more effectively? Because in the end, we really want people to not get injured by violence or whatever other things happen on a work site. So what are the ways that we can enhance the training so that this gets done in an appropriate way, and that they bring in people who actually can do a training that's legitimate? So if that's what you guys would like, I'll get in. David, do you have a suggestion on who would do that? I mean, I call Laura or Michael and just see if I can find someone to do a training specifically on workplace violence, because it's come up a bunch of times. And for Leon's folks in the stores, for example, when people are all running in there and stealing a bunch of stuff and beating the shit out of the employees, it's a real issue. It's really, or you get employees get pissed at one another. How do we stop the internal issues that people fight each other at a work site as well? That's another tasty little issue that comes up. So I think maybe we should have a discussion about that in the future. If that's what you guys would like, I'll be happy to put that together. And David,
I would definitely sign up for that.
okay.
Well, I've got to find out what the penalty is, whether it's just an OSHA citation, because that's not going to be very effective. But I think the big employers know they got to do this, and so they're doing it because they will get repeated OSHA citations. The smaller employers are not going to do it. By request to.
That'd be good. So so I can stay on if you want to talk about anything else.
No, I've got a few more minutes, so if somebody's got other questions.
All right, well, people have more questions, go for it.
David, I want to thank you for the time you've taken to give us this training. I got to go pick up my son. But thank you, everybody, and have a wonderful rest of the week.
Thanks, Rick. Take it easy.
All right,
Thank you.
organize.
Take care. Amen.
All right.
Okay. Anything else? Anyone else?
I guess I'm leaving. Am I done?
I guess. Matt?
Thank you so
Thank
much,
you very
David,
much.
for your time.
Thank you.
All right, one last word, always organize.
Yep, organized. Thank you.
Thank
Thank you, David. Thank you, David.
Oh, David's. Okay, let me have your email address. Okay. And Leon, for your folks, when I get it from David, I'll forward it to you and you can give it to whoever wants it.
Gotcha. No, that'll work. Thank you so much, Shelley.
Sure. And yeah, so if there's other stuff,